In this video, I'm going to share with you how I won my client's entire case with one single deposition. In fact, in this video, you're going to see a step-by-step plan that I implemented, some evidence, a crash report, some photos, and the actual deposition transcript so you can see exactly what was asked and what was said. And you're also going to see this intro. Welcome to Law Venture. My name's Jarrett Stone. I'm the owner of Stone Firm PLLC, but more importantly, I am your guide. I am here today to talk about depositions. And so the goal here is to share some insights, to give you some gold nuggets that you can implement in your upcoming deposition. That way you can either kill it or hopefully win the entire case. And I have to say, I'm pretty excited to give you this particular case example because it's a real case and it also deals with lies and deceptions. And when you're dealing with lies and deceptions and you're able to call those lies and deceptions out, then that makes things pretty fun. But before diving into this video, a quick and exciting announcement, which is that I plan on releasing some free online courses over at lawventure.com. Just go in your URL, type in lawventure.com and check out the courses. I know a lot of y'all have been gobbling up the content here on YouTube, and the YouTube content is going to stay here. But instead of just having YouTube videos that are out there with some links in the description, I plan on taking things a step further, a whole lot like Trial Ad Academy. That's a premium course, but with these free online content courses, that's going to basically take this YouTube content to the next level. Okay, so let's transition now back into the content of this video, talking about this particular case example. And to do that, I have to orient you a little bit, give you a little bit of context by talking about the background, which is that in this situation, I have three clients. I have the mama client and I have the two baby cub clients. And with this case, I remember getting that phone call whenever the mama client was kind of in the intake process, I'll say. I think this was a referral of some sort. But anyways, mama client calls, says that she's driving on a country back road during the day, 2-lane highway, 1 lane going each direction. And as she's driving, she sees a tow truck on the shoulder. And as she's coming closer and closer to that tow truck and she starts passing it, for reasons unknown, the tow truck decides to turn into her lane and try and conduct a U-turn. There's an impact. As a result of the impact and the force, both vehicles are pushed forward. There's, I think, another impact. And then eventually, both of the vehicles go down into a ditch and come to a stop at some point during this country back road. I'll provide photos and a little bit of more visuals, but that's the information that we have at this point. A little bit more of a background is that the defense, the tow truck driver and the tow truck driver's insurance company are denying liability. So a lawsuit had to be filed because there's two aspects to a PI case or personal injury case, where first you have to get the other side to admit that they were at fault. Second, if they are at fault, then it's a matter of figuring out how much money is going to compensate everyone accordingly. And we can't even talk about money at this point because we haven't checked off the first box. Tow truck driver saying, I'm not at fault, it's your client, and so I don't have to pay anything. So we file suit. And during the discovery process, we're getting information, we're getting production, we're getting evidence that we can potentially use if we are going to go to trial. But maybe more importantly in this situation, we're getting the evidence that we can use in a deposition. So let's talk about that evidence. Let's figure out what all went into preparing for the deposition by talking about the step one of this process, which is preparation, in order to make sure that you do your homework, in order to make sure you can develop a strategy. So the first piece of evidence to consider is probably obvious, but it's your client's stories. In this situation, I have three clients. I have three clients that have their own story that all end up matching up because they were all in the same car together. So that has some credibility, but with just their stories versus the tow truck driver stories, it's kind of a he said, she said situation. So we want to go a little bit beyond that. So the second piece of evidence that I always look at is a crash report if that's available. In this case, a crash report was available because the wreck was so severe to where someone called 911. As a result, police came out, the EMS and ambulance came out, and the investigating officer for one of the police officers that did come out did the entire investigation, talked to all the witnesses, created the crash report probably a few weeks later, and this is what the officer ended up concluding. When you look at the crash report, it states that Unit 1, which is the tow truck driver in this situation, has 2 contributing factors for the wreck. The first one is a code 37, the second one is a code 20. And then if we look at the code key, I'll say, code 37 is failure to yield right of way when turning left, and code 20 is driver inattention. The next thing that I always look at is the officer's narrative, because the officer, he's on scene, he's talking to people, he's getting a sense of what all happened. So he's a really great resource to kind of figure out what all happened. And so when looking at the narrative in this situation, there were a few things that stood out. First, he stated that he spoke with my client, who is Unit 2 in this situation, and my client stated that she was traveling and observed Unit 1, which is the tow truck driver or the defendant, and the tow truck driver attempted to make a U-turn. She stated that Unit 1, or the tow truck driver, turned right in front of her and she attempted to miss Unit 1 by swerving into the other lane, but was still struck anyways. So this is a good thing because my client's stories are matching up. Had it been a situation where my client's telling me one thing, but the officer is quoting my client saying the complete opposite, then that would be concerning, but that's not the case here. So let's dive back into the narrative and begin with this particular section, which definitely stands out. It says that when the officer spoke to the driver of Unit 1, or the defendant in this case, he stated that he was in the shoulder to make a U-turn. He also stated that he checked both ways to make sure all traffic was clear. He stated that he does not remember seeing Unit 2 or my client, so he conducted a U-turn in front of my client and caused a crash. So we have an admission from the defendant that he was attempting a U-turn, didn't see my clients, and then ended up causing the wreck. Why is liability in dispute? That's the first question that should be popping up right now, but we're gonna have to hold that question and continue on with the narrative. The narrative also says that the officer spoke to a witness who was behind my client, and the witness stated that he saw the tow truck driver slow down on the shoulder of the highway, and he then stated that the tow truck driver made a U-turn in front of my client, causing a crash. So we have mama client's story, we have the defendant's story, and we have a witness's story that are all matching up and all pointing fingers at the tow truck driver. Again, why is liability in dispute? Now this is where things take a weird turn, because the officer writes, after approximately 20 or so minutes on scene, there was a male who stated that he was upset because he believes the tow truck driver did not get a fair chance to explain himself. Who this male is, no idea. The male stated that he had a witness who saw the whole thing as well. Who the witness is, no idea. The male stated that the tow truck driver was in the main lane of traveling when he attempted to turn left into the driveway of the highway. He stated that my client attempted to pass the tow truck driver to the left. I advised the male that when I was on scene and asked if anyone else saw it, meaning the wreck, the new witness never came forward or said anything. It appears from the skid marks in the roadway that my client attempted to get out of the way of Unit 1 prior to being struck. The skid marks are way behind the driveway where the witness said the tow truck driver was turning into. So this is a little bit of a wrinkle because we have a random person number 1 quoting random person number 2, and random person number 2 is saying a story that doesn't align with my client's story, the defendant's story, and the other witness's story. Side note, there are a lot of hearsay issues and questions that should be popping up in your mind right now. I'll give bonus points and props to whoever can flush it all out in the comment section down below. So now the question in your mind should be, what position is the defendant going to take? In one situation, we have a quote of the defendant. In another situation, we have these random facts coming from random people that seem to help the defendant. Where all of this ends up going, who knows? Well, I know. But we gotta keep watching. We gotta go through more of the facts in order to figure it out. So the next thing to look at are the defendant's answers to interrogatories. And for those that don't know what interrogatories are, because that's just a weird word that nobody has ever said other than right now in discovery processes, interrogatories are sent after a lawsuit's filed. You're in that discovery process of trying to collect evidence and information. And typically they're sent before a deposition. And the reason for that is because interrogatory answers, whenever they're actually answered or not objected to, are sworn statements made by the responding party. So those sworn statements are just like somebody testifying under oath during a deposition or at trial. And so what you can do with these interrogatory questions that you're sending is say, hey, I need information on this and this and that. And so if the other side, the opposing party, ends up answering them and not just objecting and refusing to answer, then that allows you to get those answers and kind of get a feel, get a sense of what you need to talk about during your deposition. Keeping in mind, interrogatories are kind of like your softball pitch to the other side. And you'll see that in the answer that I'm about to show you, because whenever you send interrogatories, there's a totally different situation and environment that's going on to where the lawyer for the other side receives the interrogatories. They help, I'll say, draft and craft the interrogatory responses to where everything seems pretty kosher, it's safe, and it's simple, short, and sweet, which is a completely different environment than asking a one-on-one question during cross-examination or during a deposition, to where you don't really have your lawyer spoon-feeding you the answer in this situation. But in either event, that's a quick little rant. It's trying to give you a little bit of context on like why interrogatories shouldn't be solely relied on. But the point here is, in this case, we looked at the interrogatory answers, and this is what we saw. Interrogatory number 2 says, please describe in full detail how you believe the collision happened. Include in your answer the identity of each and every person who was in your automobile, observed the incident, or was present in the vicinity of the collision, giving the name, address, and telephone number of each such person. The answer to this interrogatory, we're going to go ahead and exclude the objections here. It says, subject to and without waiving the foregoing objection, which is very legalese. Defendant was traveling westbound on the highway and was turning left into a driveway. As defendant was making the left turn, he was struck by plaintiff's vehicle. There were no passengers in defendant's vehicle. Defendant refers plaintiff to his responses to requests for disclosures for fact witnesses. So the main thing to point out here is obviously the fact that the defendant's taking the position that he was turning into a random driveway off this back road country highway. That kind of rhymed, but it wasn't intended to rhyme here. And that's a little concerning because the story's flip-flopping. But the good thing here is we have this in advance, so that helps craft a little bit the game plan and strategy for the upcoming deposition, but we're not quite done yet. There's a little bit more that we need to flesh out. So at this point, I always try and look at things from the other side's perspective to figure out what the strengths and weaknesses are. So if we keep in mind that the defendant's story is that he's on this back road highway, he's making this left-hand turn, which is right on your side. He's making this left-hand turn into a random driveway, then how were the points of impact occurring? And so the first thing I looked at in this situation is the damage and the extent of damage to my client's vehicle. So I looked at the photos that my clients produced to me, that I also produced over to the other side. And then I also looked at the photos that the defense produced to me as well. And whenever I looked at the client's car, it had significant damage. As you can see, this front right side was completely shredded. It was torn to bits. It's not good. It's not something to where they were driving away to where, yeah, put a Band-Aid on it, it'll be fine. The car was totaled. Now let's take a look at the tow truck itself. And as you can see, there's clear damage over by the driver's side tire. So trying to take a step back and look at things objectively, if you're looking at the damage, it seems that there would be not a completely parallel impact, because there would never be an impact in that situation. But if this is my client, and if this is the tow truck driver, then there would be an impact slightly angled. And the question is, where on the road would this impact have occurred? And so if the defendant's taken the position that the impact didn't occur from the shoulder, but instead while he was trying to make that left-hand turn into the driveway, then the question is, was my client trying to go around the defendant in the oncoming traffic lane? And then as soon as the tow truck driver tried to make that left-hand turn, that was where the impact occurred? Because if that's the situation, then my client's case is in a little bit of trouble. Or maybe alternatively, was the defendant in that situation making that left-hand turn, but somehow my client was, I don't know, Tokyo drifting and the impact occurred that situation, if the highway's here, I think this makes sense right now. But don't worry, we'll get to the visuals in a little bit. But this is what should be going on in your mind whenever you see the positions that are being made, but then you look at the objective facts, such as the photos and the damage, and you start asking these questions of like, okay, where would this have occurred? How does the defendant's story make sense? Because even though you're on the other side, you're on the opposite side, you want to almost look at it from, with different shoes on, basically, to where you try and figure out the strengths and the weaknesses from their perspective. That way you can also figure out what their pressure points are as well. So all that preparation we just did, I consider that to be step one. Now let's talk about step two, which is taking the evidence and taking the facts and also taking the questions that you have and developing a strategy for step two. And in this situation, whenever I was preparing for this particular deposition, I knew I had questions because some of the stuff, I guess, kind of made sense from the defendant's perspective. For example, if my client was trying to pass him maybe, and then he was initiating that left-hand turn, and then it was just like a bang-bang play to where maybe that's how the impact occurred. Didn't really think that is what happened because none of the evidence other than the defendant's position really pointed to that. But if that was the position, if that was the story they were going to try and tell, then that's something that I need to know in advance. And so the best way to really try and get that information, I knew that, good thinking back to my mindset, I'm trying to be active tense right here, or present tense, but right now I'm having to go past tense. So I knew at the time that if I basically was speaking of passive, if I was passive in my questions to where they were open-ended questions, then I would be able to get the story, the full story, without cutting off the defendant. So strategy number one during step number two was ask open-ended questions in a friendly manner to kind of disarm the defendant in order to figure out the story, in order to get the facts that they may try and use at trial. And I know. Whenever you're asking questions to the other party, it feels like a cross-examination. And so it's always about leading questions during cross, and you shouldn't have open-ended questions. But during depositions, it's a different set of rules. And the reason for that is you need open-ended questions in order to get the ammunition to ultimately cross-examine about. During a trial, if there's a direct examination, then you can take some pieces here, some pieces there, and apply that to your cross-examination. But in trial, what do you do if the other side doesn't really talk about any bad facts during their direct examination? Well, the good news is hopefully you were able to have a deposition of that particular witness or party member, and you were able to get all those bad facts yourself during that deposition. And so by asking open-ended questions, that allows you to kind of get information that you may not have gotten by asking yes or no questions. And the only way you're really going to have an effective cross-examination, I'm going to use quotes now, an effective cross-examination an effective deposition by asking cross-examination like questions is if you ask like every yes or no question known to man in order to cover everything. It just, for the sake of efficiency, is a whole lot easier to have open-ended questions. And if you need to narrow that down and ultimately lead to some cross-examination questions, then feel free to do so during your deposition. A lot going on there. But that actually takes me to strategy number two, which I knew I wanted to implement in this situation. And strategy number two is coming in at some point during the deposition as hard-hitting, trying to nuke the other side's case, but more importantly, trying to show to the defendant and the defendant's attorney, whoever's calling the shots in the situation, who knows, that if you were to take this to trial, this is not going to be a fun trial. And I'll explain that in greater detail as we're going through the examples. But the point here is that if the defendant's lying through his teeth, then he needs to get a sense of what it's going to look like in front of a jury and a judge. And so my balancing act that I had to kind of perform, or I knew I needed to perform, was you want to come in hard hitting at certain points in order to show that this isn't going to be something you're going to get away with if you're lying, but you also don't want to come in too hard hitting to where it's like, hey, here's my game plan, here's my cross-examination for trial, go ahead and absorb this and prepare for trying to wiggle out of that cross-examination in the future. So it's a matter of like, you want to be open-ended in this situation to get that information. If that information is a lie, or if it's deceitful, or if it's just completely bogus, cross-examine, just hard enough to freak out the other side to where they don't really feel comfortable going to trial, but not too hard to where they're like, well, I mean, we know their script now. Let's just go ahead and take that strategy and wiggle out of it to where, I don't know, the witness or the defendant in this situation says, oh, you were asking that during the deposition? I thought you meant this, or I thought you meant that. And so you want to be able to not show too much. You want to keep it as, condensed as possible. And so you gotta have that balancing act, and that kind of comes with making calls in the moment. And we'll talk about that moment because now it's time to talk about step number 3, which is executing the strategy that you've come up with. Wow. Okay, that was a lot that I was trying to push through because somebody somewhere keeps turning on a leaf blower, and I feel like they keep turning it on as soon as I start talking, and they didn't turn it on at that point. So I was just trying to push it all out. But anyways, as I'm catching my breath, be sure to hit that like button, because if you're still watching at this point, I think that's a sign you're liking this video. So that button is over there. Also over by that button, by that like button. If you go a little bit lower, that's the subscribe button. Don't forget to hit that. That way you can see future videos and future content. Okay, so we're moving on to step 3. It's a matter of executing this game plan that we have. As a quick reminder, the game plan is all about asking open-ended questions, getting a feel for the other side's position, getting a feel for the defendant's arguments and story, and then if need be, come in hard-hitting to show that their case isn't going to look good in front of the judge and the jury, but not too hard-hitting to where we show our hand and they feel comfortable about trying to wiggle out of what we're trying to, flex on. And the best way to kind of show how this deposition unfolded is probably to go through the deposition transcript itself. But don't worry, I'm not gonna go through the whole deposition transcript. I'm not gonna bore you like that. But I do wanna touch on certain topics and then provide a little bit of commentary to give you some extra perspective on what all's going on. So with this particular deposition, it didn't take me too long to start getting into the meat of the case, to start getting into the story and the position that the defendant was going to take. In particular, I asked, at any point in time while you were driving on highway, did you pull over and stop? Defendant answered no. So I asked, so at no point on highway did you ever come to a stop? No. Can you explain to me what all happened right before the collision? Okay, so quick timeout. Let's talk strategy very briefly. By asking this question, at any point in time while you were driving on highway, did you pull over and stop? It's a friendly, open question that's not super open-ended, like what's the meaning of life? And it's not so closed off like a leading question to where it necessitates a yes or no. This potential balance that I'm trying to strike with this question is that if I'm asking a leading question, then there's going to be kind of the signal to the defendant that, hey, I'm about to touch on something important. Now this is your time to be defensive and try and evade, which is basically what's going through a lot of witnesses' minds when they hear a leading question. But I don't want to ask an open-ended question at this point that's overly open-ended, because then he may start talking about something else, and I'm not able to get the fact that I want to ultimately pin him down on. And what I ended up getting in this situation is a clear admission from the defendant in a friendly manner that he may not even realize he gave me, which is the fact that he never stopped while on the highway. And that's counter to what the other evidence was showing, but the fact that he said that he was never stopped on the highway at any point, whether that's on the shoulder or on the highway itself, that's a good fact that I want to have in my back pocket in case I need to later impeach the defendant. And I was able to get that in a very friendly and kind of passive manner. So right after this series of questions, I immediately ask, can you explain to me what all happened right before the collision? Again, open-ended question, nothing that's going to really arm the defendant to feel like he needs to start avoiding, and these red flags probably aren't going in his mind. So he ends up saying, I was on going west, I was going to go into a driveway, I was starting to take my turn, and then I felt a car strike me. So this is another example of asking an open-ended question that really solidifies and puts on the record and pins the defendant down on his position, which was that he was not conducting a U-turn, but instead was trying to make that left-hand turn into the random driveway. Other portions of the deposition shortly after, he's saying that the reason why he was trying to turn into the driveway was so he can ultimately turn around and go the other direction like a U-turn, but I'll spare you the details on that one. Another strategy that I started to use kind of in the moment was that I didn't want to have a natural and clean segue from one topic to the next, or to one point I want to make to the next. Instead, I kind of went down little rabbit holes here and there, knowing that I would circle back to a point that I ultimately wanted to pin the defendant down on, but I didn't want to really show my hand to where it was obvious that I was immediately going to start talking about the U-turns or anything like that. Instead, what I ended up doing was going down a series of questions like, okay, why were you trying to go the other direction? Who were you trying to see? What were you driving? The tow truck? What kind of car is that? Okay, how big is that? And then ultimately coming back to the surrounding facts of him making that left-hand turn. And the next series of questions that I ended up asking kind of didn't seem attached to the previous questions, those little random tidbit fact questions. But in reality, what they were actually doing was building upon the questions that you just saw. And so the next series of questions, and I said questions a whole lot, involved this. Can you describe the road whenever you are attempting to make that left turn into the driveway? There are 2 lanes right there, one in one direction and one the other direction. Before arriving at the place where I had to make the turn, I put on my signal to signal the turn. Then I slowed down so I could turn into that driveway. Did you see any cars in front of you? No. Did you see any cars behind you? No. So at no point while you were making that turn did you see any cars? No. And while you were making that turn, you are making that turn from the actual lane heading west? Yes. At no point in time were you ever in the shoulder that heads in the west direction? No. Do you consider what you were doing to be a U-turn? Definitely no. So here I started with open-ended questions, and then I started funneling those open-ended questions down to more direct questions because we started to get to something that was very important. For example, the fact that he takes the definitely no position on whether or not he was making a U-turn. That's important because we have witnesses that say otherwise. I also asked questions that confirmed that he didn't see any cars ahead of him and he didn't see any cars behind him. Now I could have basically expanded on those questions and taken them a step further by really pinning him down on the fact that he either didn't look to see my client behind him, or my client, and this could be the ridiculous position that he took, was traveling at the speed of light. And that's why whenever he looked, he couldn't see my client. In either event, I didn't really want to showcase those points because that could be a totally different cross-examination to where I pinned down the fact that he wasn't really paying attention while he was driving, or he's just coming up with this absurd story. But I didn't want to showcase that part of the deposition or those series of questions in order to tip my hand for the potential trial. So I was able to get the facts that I could use to ultimately lead to additional cross-examinations, but I bit my tongue a little bit to where I knew they were going to be beneficial. I didn't really need to beat him over the head with the points I ultimately would prove at trial. So now this is where things get pretty interesting because the defendant starts volunteering facts that really show how absurd his story is. In particular, after he says definitely no, I ask, so at what point in the road did the first collision with my client occur? The attorney on the case objected to form. In the state of Texas, your deposition objections are typically form, and form can apply to a whole bunch of other objections, which, by the way, speaking of objections, be sure to check out the 21 trial objections cheat sheet. Super helpful. There's been over, I think, 3,000 downloads, which is just crazy. You can get that in the description down below. Now, ignoring the objection, because I think the objection is to the fact that I'm talking about the first collision and maybe I haven't established that there were multiple collisions. I don't know. But in either event, I get an answer from the witness. The defendant ends up saying, I had already taken my turn. I was already about 80 or 90% onto that road when I got hit. I ask, are you saying you are 80 or 90% in the driveway? No, I was 80 or 90% already in the opposite direction lane. So is it your position that my client was attempting to pass you while you were simultaneously making that left-hand turn? Yes. And at no point you ever came to a stop, you were continuously driving. I think there was a quick deposition typo there, but who knows? The answer, no. What happened after the first impact? Another objection was made, but the witness ended up answering, after the first impact, I started looking for my telephone. In that situation, I realized I was on 2 different pages to where I think he thought I was maybe asking another question. So it was a matter of me orienting him a little bit with an additional question. And that orientation led me to asking, I'll take a step back and that way we can unpack this a little bit more. Whenever the collision occurred, where on your tow truck were you impacted? on the tire, on the front tire. On the left side, on the left side. Just to be clear, the driver's side, yes. So just so I'm understanding, your position is as you are turning and basically strike that. By the way, sometimes whenever you're asking questions in the moment in a deposition, you realize, oh, I can maybe ask a better question, or I can ask additional questions that ultimately get to the point I'm trying to make. So you may want to stop yourself and just strike the question altogether. That way there's no confusion on what you're asking. So after striking that question, I end up asking, when the impact occurred, what direction was the front of your tow truck facing? The driveway. This is important because the direction that the tow truck is facing is really going to show us where on the road he's claiming he was. And if he's claiming he's facing the driveway, then things kind of get a little weird, but we'll talk about that in a second. The next question, so it's your position that as you're basically covering up the majority of the road, my client was trying to squeeze into the oncoming traffic lane. Objection form, defendant asks, can you repeat the question, please? Side note, whenever you get a, can you repeat that? That's typically a sign that they realize that their answer isn't very good, so they need some extra time to come up with a better answer. So while your vehicle is facing the driveway and your vehicle is covering the 80 or 90% of the eastbound traffic lane, it's your position that my client was trying to squeeze into the eastbound lane with the remaining 10 or 20% that was available? I think so, yes. So one thing about me reading these deposition transcripts to you and the questions and answers is that I'm trying to be relatively monotone and objective while also giving you a little bit of voice inflection for getting a feel in the moment and also not boring you to death. But what you're not seeing with this black and white reading is the facial expression that I'm making whenever he gives a really weird depiction of what happened. In fact, whenever I ask the question, so while your vehicle is facing the driveway and your vehicle is covering 80 to 90% of the eastbound traffic lane, it's your position that my client was trying to squeeze into the eastbound lane with the remaining 10 or 20% that was available. This was my face. And then whenever he says, I think so, yes. One, there was a pause that he had that was pretty substantial. But whenever he said that answer, my eyes went immediately to the defense lawyer like, are you really? Is that what he's gonna say? Okay. And that right there blew my mind, and I'll show you exactly why. Cool. I think that's better. I don't know. So here's my horrible drawing of the story that this tow truck driver is trying to spin for you. So here in green, we have the tow truck driver. Here in blue, we have my client, 2 client kiddos. Over here, we have the driveway. I think you can see, I don't know if it's cropped out, but we have the arrow showing that this is where the traffic is going, and this is the direction where this traffic and these cars were headed originally. And over here, we have the shoulder where, according to my client and a lot of the facts, I'll say, I'm trying to be objective here, my client's coming up, tow truck driver's here, decides to hit. Y'all saw the police report. That's where, and they end up over here. But this 80-90% thing is pretty incredible. I mean, I have to say, it's pretty incredible because what ends up happening in this situation is he's saying the tow truck is basically covering that 80 or 90% of the oncoming traffic lane. So his point here is that my client with her 2 kiddos decides to go around and try and beat this tow truck in front within the remaining 10-20% of the lane with oncoming traffic in order to beat the tow truck right there. I'm sorry, I'm a little speechless. The crazy part about this is the fact that she could have really just gone this direction behind, not risked her kids, and still would have achieved the goal that she was trying to achieve. This only leads to one conclusion, which is that my client, spoiler alert, is Vin Diesel. And if we take things a step further, and I'll show photos of where the cars and vehicles ended up, they basically ended up with client's car, sorry, I'm having a hold right there, and tow truck, right, we'll do a bigger X because it was kind of more forward, right there. So somehow there's an impact with this portion of the vehicle, this portion of the vehicle, with him, remember, facing the driveway, and then managing to end up right next to the driveway to where they somehow get pushed and then move forward. It doesn't add up. The traffic or the lane of travel that he's trying to convey, you can tell he hasn't really thought out. Now, one thing I do want to mention is I very easily could have come up with this horrible drawing in front of him, called him out on it, and tried to figure out what exactly is going on when my client and her 2 kids could have easily avoided all of this. The reason why I didn't do this, again, is because I didn't want to showcase the meat of what I would present to the jury in advance. That way they would kind of be taken surprise once I kind of did this little horrible drawing in front of the jury to show that unless my client's Vin Diesel, and then I'll look at my client and say, she doesn't look like him, then most likely any rational person is going to take this approach. And so this story as a whole isn't lining up. And then you also want to look at the other facts, and you'll see that those facts defeat this entire story. So the validity of and the credibility of this defendant should be 0. But we're not done yet. There's still portions of the deposition that we need to talk about in order to really flesh out why all of this just doesn't work. So earlier I was talking about how you may want to ask a series of questions that ultimately get the points that you want on the record, but also sprinkling in some rabbit hole questions to help throw the rhythm off a little bit. And that way the defendant or the witness that you're deposing doesn't really get a feel and anticipate where you're headed and try and redirect it or try and come up with an answer in anticipation of those questions. And a great example of being able to go down those rabbit holes and reposition and basically cause a witness to flip ended up happening in this situation. In particular, at some point, whenever I asked if the defendant could describe the impact, the defendant said, with the impact I received, I was pushed out and it was just barely a minimum impact, just a little bump. First of all, the photos show that this wasn't just a little bump, and that basically defeats what he's saying right here and shows that he isn't very credible. Second, this is something though that would maybe give me a little concern that I want to head off before a trial, because if his position was this was a slight impact, then there's going to be a potential argument that as a result, there shouldn't be injuries, or the injuries aren't as bad as the plaintiffs are saying in this situation. And so I decided in the moment that I wanted to head off these potential arguments by getting the defendant to admit that this wasn't just a little bump. But I went down my rabbit hole questions first and then circled back later on. How would you describe the severity of the wreck? I never realized how severe it was. How severe do you think it was? Objection form. Couldn't have been too hard. My truck is still circulating in spite of having received that damage. Have you been in a wreck before? Yes. Would you describe this wreck that occurred in October of 2017, which is the wreck that the deposition is about, as more severe than that, I'll say, other wreck? Objection form. The defendant says it's also minimum damage also. In other words, he's saying both this current wreck that we're here for and this other wreck, minimum damage also. So if 0 were to be a slight fender bender just with a bump, and 10 would be a severe as a wreck possible, where would you put this on that scale? The October 2017 wreck, the one that brings us here together today for this particular deposition. Objection form. The defendant says just above a fender bender, just a very slight bang, bump of the vehicles. So it's your position that a very slight bump pushed your car or your tow truck that was only traveling at a max 20 miles an hour through a ditch and into a fence. Objection form. I don't know how fast the other vehicle was coming. And I don't know if you can tell in this situation, he's trying to basically answer the question without actually answering the question. So it's all about bringing him back in. I'm not asking how fast the vehicle was going. I'm trying to get an idea of your opinion on this entire case, basically. So it's your opinion that the collision that brings us here today is just a notch above a fender bender. Objection form. The defendant says, you got me mixed up. We were talking about the other crash that I had before. This crash was significantly harder crash, and he did push me and I didn't end up hitting the fence hard, but I did get a strong impact. So I originally was asking about a previous wreck just willy-nilly in the moment. I don't know if people say willy-nilly these days, but anyways, in the moment, because I wanted to do this kind of compare contrast series of questions that seemed like a good idea at the time. But the fact that he said that both wrecks were just, slight bumps in this whole also thing. And I decided to pivot a little bit. Okay, let's ask another series of questions to figure out, does he really think, and is he really gonna take this strange position that the fact my client's car is totaled is because it was just a notch over this fender bender? Well, after those few series of questions, it's now like, oh no, I'm confused. What I was talking about earlier with the also, those are two separate wrecks, and this one is actually a significant impact. And that right there is the point that I needed to make, because now they really can't take the position that, oh, it's not a significant impact, slight fender bender, so plaintiffs aren't really that hurt. I don't think it would have been a very convincing argument, but if you can take that argument away at the very beginning during the deposition stage, then that's just one less defense that they're able to make, and it helps simplify things for the judge and jury. That's always a good thing. The gold nugget to take out of this series of questions is basically there are times where you do want to ask those leading questions to really pin that person down, to not only prove the point that the defendant's position is absolutely ridiculous, but also to give the defendant and opposing counsel a sense of how the cross-examination at trial is going to go. I was about to move on, but I just realized that somebody may be watching this thinking, okay, you got to go in for the kill, cross-examine. Now's the time to really draw blood. There's a way to cross-examine to where you're looking confused, and it's like, am I really hearing what I'm hearing without being a jerk about it? And so it's a little bit of a fine line, and you don't need to be mean or abrasive, but instead just, try and be professional, but confused. Like, really, man? You're saying the accident or the wreck that ended up causing my client's car to be totaled and pushed by this 30-foot truck was just a slight fender bender? Like that face right there does everything you need to do. And that's basically the face that the jury's gonna have whenever they hear the defendant being cross-examined at trial, flipping and flopping all over like a fish. I don't know if that ending is something I'm gonna keep, but we'll find out. One final section that I want to touch on. I ended up asking, is it your position that the officer never spoke to you about driving on the shoulder? Answer, he never asked me any questions. That is what he stated. And so that statement that I just read is false by the officer. Yes. And the report by the officer talking about the U-turn, you never made that statement either? No. So is it your position that the officer lied on his report? Yes. That right there is extremely important, because I know that police officers do not want to come testify at a civil trial. But with this deposition transcript, I knew that the odds of getting that officer on board, basically on my team, would be exponentially higher if the officer knew that the defendant was calling him a liar. That's not a good combination for the defendant. So those are the highlights of the deposition. And with all of that, not only do we have the photo evidence, not only do we have the officer's statements, not only do we have a witness, not only do we have the plaintiff's story, but we have a really ridiculous story that doesn't really match up by the defendant. We also have the defendant flip-flopping, and we have the defendant calling the officer a liar. There's a lot of shadiness that is going on the defendant's side. And we also have these random people that nobody knows who they are, who we're talking about, random witnesses that really have nothing to do with the case, because they're randos and nobody knows who they are. So with all that said, there was a whole bunch of facts that are favorable to my client's side based on this deposition. And there were a whole lot of, I'll just say, tales from the tow truck driver. Sounds like a horrible book that you wouldn't want your kids to read. Now, the best part about all of this is that the opposing counsel witnessed all of this and was able to get a feel about how this would be presented to the jury. So fast forward a little bit in time, and I'm now in a mediation sitting next to mama client, and in another room is the opposing counsel, I think the adjuster, and definitely not the tow truck driver, the defendant. And it just so happens that after all of that deposition testimony came to light, that now the defendant is accepting liability, and now opposing counsel is making offers, and the offers basically have a little bit of a premium because the defendant was lying through his teeth on the record. Doesn't look good. So clients were able to get a nice chunk of money that made them super happy, all because the deposition went super well. That started with great preparation, and then it ended with execution. And so my goal here, my hope here, is that this example allows you to take little tidbits and nuggets and apply it in your situation, whether you're preparing for a deposition that you're about to grill someone on, or be passive, use whatever strategy is best, or if you're trying to anticipate what somebody else's deposition is going to feel like, especially because everyone obviously watches law venture videos. That sums up this video, but before you go, you know the drill. If you're still watching, then be sure to hit the like button, be sure to subscribe, be sure to comment down below with any questions, comments, concerns. But here's another wrinkle in the equation. Don't forget to go over to lawventure.com, check out the free online courses, and go get your fix.